may be seated.
You have the copy for them. You got 16, right?
I think I printed 16.
You want to count? What? Oh, yeah. Forgot that. Hmm. 16, 15. All right. We are ready for the jury. Would you hand these to Officer Howell? Ladies and gentlemen, while those copies of your copies of the charge are being handed out to you, let me instruct you one. If you remember at the beginning, I advised you that statements and arguments and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they're not evidence. If any statements that were made to you that you believe are not supported by the evidence, then you're free to disregard them. Now, all right, ladies and gentlemen, if you all have your copy, if you'll read along with me. This is the sentencing jury charge of the court. Members of the jury, you have now found the defendant guilty beyond a reasonable doubt of murder in the first degree as charged in counts 2 and 3 of the indictment number 22 CC 2018 CR 267. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of murder in the first degree shall be punished by death, by imprisonment for life without possibility of parole, or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years for such sentence. A defendant who receives a sentence of life imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt, and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt-finding phase or the sentencing phase, or both. The jury is the sole judge of the facts and of the law as it applies to the facts in the case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given to the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravating circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. You may consider this victim impact evidence in determining the appropriateness of the death penalty only if you first find the existence of one or more aggravating circumstances has been proven beyond a reasonable doubt by evidence independent from the victim impact evidence, and find that the aggravating circumstances outweigh the finding of one or more mitigating circumstances beyond a reasonable doubt. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The burden of proof beyond a reasonable doubt in this sentencing hearing is on the state as contained in these instructions. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Tennessee law provides that no sentence of death or sentence of imprisonment for life without possibility of parole shall be imposed by a jury but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. As to count 2, premeditated first-degree murder, 1, the defendant was previously convicted of one or more felonies other than the present charge, the statutory elements of which involve the use of violence to the person. The state is relying upon the crime of aggravated assault, the statutory elements of which involve the use of violence to the person. 2, the murder was especially heinous, atrocious, or cruel in that it involves torture or serious physical abuse beyond that necessary to produce death. 3, the murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant or another. 4, the murder was committed against a law enforcement officer who was engaged in the performance of official duties, and the defendant knew or reasonably should have known that such victim was a law enforcement officer engaged in the performance of official duties. 5, the defendant knowingly mutilated the body of the victim after death. As to count 3, first-degree murder in the perpetration, the defendant was previously convicted of one or more felonies other than the present charge, the statutory elements of which involve the use of violence to the person. The state is relying upon the crime of aggravated assault, the statutory elements of which involve the use of violence to the person. 2, the murder was especially heinous, atrocious, or cruel in that it involves torture or serious physical abuse beyond that necessary to produce death. 3, the murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant or another. 4, the murder was committed against any law enforcement officer who was engaged in the performance of official duties, and the defendant knew or reasonably should have known that such victim was a law enforcement officer engaged in the performance of official duties. And 5, the defendant knowingly mutilated the body of the victim after death. You are instructed that the word knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Heinous means grossly wicked or reprehensible, abominable, odious, vile. Atrocious means extremely evil or cruel, monstrous, exceptionally bad, abominable. Cruel means disposed to inflict pain or suffering, causing suffering, painful. Torture means the infliction of severe physical or mental pain upon the victim while he or she remains alive and conscious. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether the death penalty or imprisonment for life without possibility of parole would be an appropriate punishment in this case. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, whether the defendant was the product of a dysfunctional family subject to abuse. 2, any history of childhood psychological, physical, emotional, or sexual abuse. 3, any history of the defendant's neurological conditions or deficiencies and any treatment history or lack of treatment. 4, any proof that the defendant's positive conduct while incarcerated. 5, any proof of defendant's positive conduct in relationships with others. 6, any proof that shows that he has family members that will provide him with love and support while in prison. 7, any active relationship that he may have with his child although in jail. 8, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made a part of this charge as the verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravating circumstance or circumstances have been proven by the state beyond a reasonable doubt, but that said statutory aggravating circumstance or circumstances have not been proven by the state to outweigh any mitigating circumstances beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravating circumstances or circumstances proven by the state beyond a reasonable doubt and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravating circumstance or circumstances so found and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. We, the jury, unanimously find that such statutory aggravating circumstance or circumstances do not outweigh any mitigating circumstance or circumstances beyond a reasonable doubt. Therefore, you shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, Are we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life? The verdict must be unanimous and signed by each juror. If you unanimously determine that at least one statutory aggravating circumstance or several statutory aggravating circumstances have been proven by the state beyond a reasonable doubt, and that said circumstance or circumstances have been proven by the state to outweigh any mitigating circumstance or circumstances beyond a reasonable doubt, the sentence shall be death. The jury shall reduce to writing the statutory aggravating circumstance or statutory aggravating circumstances so found, and signify that the state has proven beyond a reasonable doubt that the statutory aggravating circumstance or circumstances outweigh any mitigating circumstances. You will write your findings and verdict upon the enclosed form attached hereto and made a part of this charge. Your verdict shall be as follows. We, the jury, unanimously find that the following listed statutory aggravated circumstance or circumstances beyond a reasonable doubt. We, the jury, unanimously find that the state has proven beyond a reasonable doubt that the statutory aggravating circumstance or circumstances so listed above outweigh any mitigating circumstances. Therefore, we, the jury, unanimously find that the punishment shall be death. The verdict must be unanimous and signed by each juror. Take the case, consider the evidence, all of the evidence, fairly and impartially. Complete one of the three forms for both counts and report your verdicts to the court. And ladies and gentlemen, I have the forms that are referred to there, and you will be able to go through them and see that the forms start with the first, as in the charge, they start with the first life imprisonment, punishment for life imprisonment, and you move through these forms according to what your findings are. But if you have any questions about how to interpret them, please let the bailiffs know and we'll bring you back into court. But otherwise, these forms should assist you in arriving at your verdict. And with that, ladies and gentlemen, I believe this will be the conclusion of my instructions, and you may now retire to begin your deliberations. The three of you who are the alternates, if you'll remain in the courtroom, please. All right, jury may now retire. All of the exhibits, other than the video, audio, will need to go back with the jury. The trial exhibits.
And the charges and the charge.
Yeah, the original charges on all of both the introduction and the final charge for guilt or innocence, as well as. Thank you. I told you all along that yours is one of the more difficult positions to be in because you have been our standby. It's kind of like you're a Major League Baseball player waiting for your big day, and you don't have the opportunity to actually get into it. So at this point, we will not be able to substitute you for one of the jurors who are deliberating. So you have the option of letting us arrange for you to get you on back home to Knoxville, or if you want to wait around a little while, then we can do that if you'd like. But if you'll talk to the bailiffs and to the clerk, they'll talk with you about what needs to be done. You are now free to discuss the case with anyone and everyone that you want to. You're not required to, but you three can talk among yourselves finally about your opinions of the case and so forth. So thank you again for your cooperation and your help. Couldn't have done it without you, even though you didn't really get to participate in the deliberations, but certainly we thank you for your patience and your cooperation. And if you'll step back with Officer Howell, he'll put you where we need to put you. All right, anything then before we recess pending the return of the jury? Then we shall stand in recess pending the return of the jury.